Court is now in session. Bottom of page 2, Jennifer Smoot-Fair versus Mark Wojciechowski.
For the record, this matter is before the court, and the defendant father's objection to a referee recommend order, which denied his motion for 50-50 parenting time, but did grant him additional parenting time, from what was previously permitted and ordered. The hearing is being conducted via Zoom, and the defendant father petitioner is present. Is Jennifer Smoot-Fair present on audio? It appears that she is not. This matter was scheduled for 11 a.m. It's 11:30. The plaintiff's mother, Jennifer Smoot-Fair, has not appeared. It appears at the front of the court. Bernie Misted mail a copy of this objection and notice of hearing to the plaintiff's mother on December 20, 2023. Sir, how do you pronounce your last name?
Wojciechowski.
Wojciechowski. All right, Mr. Wojciechowski, you've conferred with Ms. Patrick from the front of the court.
Yes.
Was provide the court with the following recommendation, noting that Jennifer failed to appear.
Okay.
You recommend. Now, when did you last speak with her?
Who's that?
Jennifer.
The last time I picked up the kids.
Was there any discussion about the hearing for today?
No.
Okay. All right. The recommendation this morning is that the referee recommend order be rescinded and canceled, and that you should be granted parenting time every Wednesday, 4 p.m. pickup at Highlight in Monroe, and back to school on Friday mornings or until 4 p.m. if there's no school. You should have every other weekend, Fridays until Sundays as previously ordered, and the parenting time drop off on Sundays will be the LaSalle post office.
Okay. When I was going to ask, when does this start?
Well, probably next Wednesday, because obviously Jennifer's not here and she's not aware of this order, so she'll have to mail a copy.
Okay.
So it would have started a week from today, since your parenting time is every Wednesday.
All right.
Now you live in Bedford, is that correct? And the children attend Monroe Public Schools?
Yes.
Okay. And your motion for additional parent time is because mom has moved back to the Monroe area with the children after being gone for a number of years.
Yeah.
Okay. Are you able to get to the children's school on time?
Yeah, because I actually work in Monroe.
Okay, but what time do you start work?
7.
So you got to bring the children to school, what, 6:45?
Yeah.
Isn't that awfully early?
Well, my son starts school at like 7:15, 7:20.
Of course, you had a 15-minute drive from Bedford. How long does it take you to drive from Bedford to Monroe?
Like it takes me like 15 minutes. 15.
All right.
Yeah.
And you have to be to work at what time? 6:30?
7.
7?
Yeah.
How about your daughter? What time does she start school?
She starts at 7:50. So she starts at almost 8 o'clock in the morning. So my thing on that one is she'll have to get up a little earlier than normal. So when I'm on my way to school, or not school, to work, I can either drop her back off at her mom's and she can catch the bus there, or I have a nephew that goes to the same school and I can drop her off at my sister's house and they can ride the bus together.
So you'll discuss that with your daughter?
I discussed it?
Will you?
Yes.
And she's 14. Obviously, you want to make sure that she's comfortable going to school with your nephew.
Yeah.
And she may prefer to be dropped off at mom's house, and will mom be there in the morning?
She should be.
Right. Obviously, the court's concern is you're getting these children up awfully early to drive them to school. Are you willing and capable of helping them with their homework?
I have no problem helping them with their homework.
Okay, so every night you got to go through their backpacks.
Yeah.
Wednesday and Thursday nights.
Mm-hmm.
You're going to do that?
Yes.
Even if they tell you they have no homework, you're going to go through with them what they did that day in school. Is that correct?
Yes.
Do the children go to two different schools here in Monroe? One at junior high and then one high school?
Yeah, one's at the high school and one's in the middle school.
Okay. So, you know,
Next year, my daughter will be in the high school as well with my son.
okay. So you're picking them up at 4 o'clock at different locations then, right?
No,
I'm sorry, picking them up at Highlight.
yeah, it'll be at the same location.
Does Jennifer work on Wednesdays? How will the children get from school to the Highlight on Wednesdays?
I'm assuming Jen will have to bring them to me. Like I don't know how she's going to, if she has to work or not.
Well, that's the problem. If she's got to work on Wednesday, she's not available then to drop them off at Highlight for you to pick up.
I don't know. She works. I guess she works midnights.
You don't know?
I don't know.
Okay, can you text her, see whether she can appear this morning?
She don't tell me her work schedule.
Well, but I don't want the children just to, Miss Patrick, the court's still concerned about, we don't know if mom can get the kids to the Highlight school. Should dad be picking them from school?
He has to work, and part of the objection is he stated also when I was talking to him that him and mom had talked about this, not being an overnight, but on Tuesdays and Thursdays to do this. So I have to assume that she can do it. I don't know that for a fact. Because I believe the high school gets her out around 2, and I think the middle school is about 2:30. So
yeah.
What time do you get off work, sir?
I get off work at 3:30.
Okay, so the kids are gonna be sitting at Highlight for a half hour?
Not if they're at they normally take the bus. They normally take the bus home.
Okay, do they live next door to Highlight?
No.
All right, is this recommendation
they're like 5 minutes. Oh, sorry.
All right, this recommendation, you can pick up the children on Wednesdays at 4 o'clock at Highlight. So how are you gonna get there? You're off at 3:30 though, so you can be there by 4, correct?
Yes.
All right. You previously just wanted Tuesdays and Thursdays from 3:30 to 8. Now you want overnights?
Well, she was going to give me the Tuesdays and Thursdays because I originally wanted a week on, a week off.
But you originally just wanted the evening parenting time, not overnight.
No, I didn't want it. I wanted the overnights. Jen wanted me to have the couple hours for Tuesdays and Thursdays.
Okay. But today you want more than the Tuesday and Thursday afternoons.
Well, the Mary Patrice, she recommended I do the Wednesday through Friday, and then on my weekend that I would get Wednesday through Sunday.
Those recommendations, you have plenty of time every Wednesday at 4 p.m. until back to school Friday morning, or 4 p.m. if no school. In addition, you have alternate weekends, Friday till Sunday, as previously ordered. So every other weekend, Mr. Wachowski will have plenty of time from Wednesday till Sunday. Is that correct, Ms. Patrick, on this recommendation?
that's correct, Your Honor. It's kind of a middle ground. He initially filed a motion to change parenting time, which the referee, I believe rightfully so, denied because week on, week off would really be a change of custody. So this recommendation is more of like a middle ground. We're not changing the overnights closer to an equal because an equal would be a change of custody. And I did explain that to Dad. So you're correct. Week one, he would have Wednesday through Sunday. Week two, he would only have Wednesday and Thursday overnight.
All right, well, give us a try. What the court's concerned about with the children being at school. We'll give us a try, particularly since Jennifer failed to appear this morning. We don't know why.
Well, and Your Honor, I just want to point out to the court, I'm sure you've noticed that this, the first time we did not have service. This time, the front of the court perfected service on this.
Yes, I do note that. Two things, if you could just bring to the attention of Ms. Hamrick.
Yes, Your Honor.
She referenced in her order, and the court does read these. She says the children attend Bedford schools. That's not accurate.
Yep.
And that's irrelevant. And then where the very bottom where it says recommend the final order be entered, it says plaintiff's motion to change parenting time. That's defendant's motion. She's got to pay more attention to these little details. So if you can point those things out to her.
I will, Your Honor, and that would also be why I set aside the order, just so the court knows.
Okay. Yeah,
It's not an
confusing
accurate order.
And the court's reading it, of course, then I go through the file. Yes, it's defendant's motion to change parenting time, not plaintiff's motion. She, at the top, she indicates defendant's motion, but then at the bottom in the order, she puts plaintiff's motion. And the children do not attend Bedford schools, but rather Monroe Public Schools. In any event, when do you recommend that this begin then, Ms. Patrick?
I'm with the court, Your Honor. I believe that it should start next weekend or next Wednesday. I don't know if this coming weekend is his or not, but this order will not change his weekends.
Yes, it is my weekend.
So I suggest next Wednesday, Your Honor, because you're correct.
Okay.
She won't have a copy until next week. That'll be mailed probably tomorrow or Thursday morning.
All right. So, sir, this you didn't answer your question again. This Wednesday, every Wednesday to Friday will begin a week from today, but you'll have your weekend parenting time Friday. I believe it's whatever is pre-sorted, Friday to Sunday.
Okay.
Okay.
All right.
But obviously you can communicate with mother and let her know when you exchange that she missed a court date and the parenting time has been modified. She'll be receiving a copy of this.
Okay.
And make sure if in fact this is stress out your children, I'd hope you'd be sensitive to that. Getting up so early, 5:30 in the morning to get to school, to drive from Bedford to Monroe. If it's an issue, you've got to do what's best for your children.
Okay.
All right. Court will adopt the recommendation. We mailed a copy of this. Thank you, Ms. Patrick. Okay, you can zoom out, sir.
Thank you.
Thank you. Welcome, this matter is before the court for continuing pre-trial conference subsequent to mediation. President is Attorney Ron French. Good afternoon, Mr. French.
Good afternoon, Judge. Good to see you, albeit by Zoom. For the record, Ron French appearing on behalf of Phil Brock.
And Mr. Brock is also present.
Yes.
When the court ordered this mediation, Mr. Musson represented and appeared on behalf of Mr. Brock. So he's the attorney of record. He's never filed a motion to withdraw. Have you tried to call Mr. Musson to find out where he's at?
He was the attorney for Mrs. Brock, you said, or Mr.?
Yes, for Mrs.
Yeah, because I did speak with Mr. Musson. He told me that there was a limited appearance on behalf of her, and he had exceeded that and finished his representation with her. And
the court does not accept that. He did tell me that on December 8th. We had a teleconference, did we not?
We did, Your Honor.
He did tell me he was not going to appear for this mediation.
That's what he told. He represented to me, Your Honor. I have nothing else on that other than what he represented to me. We emailed pleadings and whatnot to her directly after he told me that, Your Honor. And like you said, we did not receive a order for him to withdraw from the court. So,
all right. And Ms. Brock has not appeared. Obviously, this matter was set for 1:30.
No, she did not.
All right. It does not appear that you filed a counter complaint for divorce in this file, did you?
No, we did not. We just answered.
All right. The court has an alternative to enter an order of dismissing this divorce complaint since the plaintiff has failed to appear and his attorney, and her attorney, I should say. I will put a call into Mr. Scanlon and Mr. Musson, let him know that the court will not allow him to file limited appearance anymore, especially when he appears at the pretrial when we set this and he does not appear for the mediation. You should have told me at that point in time his services were done. The court's not real happy with him.
Your Honor,
So
you want me to try to give brother counsel a call right now?
Yeah, I tell him that I want him to zoom in.
Can I have 2 minutes to do that off the record, please?
I am. Again, unless you client appear for this mediation after the court is entering an order of dismissal.
Well, we're going to have to refile that, Your Honor, in any event. So I'd like to get him on so that we can maybe keep this moving.
Unless he get his client here to mediate, this court can enter dismissal and Mr. Brock can file.
Okay, let
But
me.
yes, if you want to get, we can put you in a breakout room if you want to call Mr. Mussa and tell him the court's not real pleased. And I would tell him that and if you can get him to appear to zoom in.
Let me see if I can get a hold of him, Your Honor. I'd like to at
Right,
least.
thank you, Mr. French.
Thank you, Your Honor.
I will put them in.
That's wrong.
Yeah. How long does a limited appearance last? I mean, I know that doesn't make any difference, but what is the limited appearance? They only do so much?
Yeah, I mean,
But then when are they out?
it says when this limited scope is ordered here, it says, his parents, when this limited scope of representation has, the attorney will file a notice of withdrawal with the court. He's not done that.
Yeah.
I'm just looking at, I noticed, I'm
I'm
not sure here.
I don't
See that in the last paragraph?
You mailed it today, you should get it.
Oh, good. Okay, so in the future, I know to look for a notice for withdrawal.
Oh,
Okay, yeah, okay, thanks for
I
explaining.
guess he doesn't need to file an order, but notice.
Okay, okay.
And
And
now we'll
then
have to-
nothing's filed, so. Eric Sims.
For the record, this matter is before the court and adjourned. The noble hearing on the defendant's objections to recommended order that denied his motion to reinstate parenting time for the reason that Mr. Sims had failed to appear for that referee hearing. The matter was adjourned to today's date as the plaintiff's mother, Ms. Toll, wished to recontact Attorney Maria Zagorski, who's present for the Zoom here this afternoon. Good afternoon, Mr. Zagorski.
Good afternoon, Your Honor.
So Ms. Zagorski is present on behalf of the plaintiff's mother, Kendall and Toll. Ms. Toll is present, as is the defendant, Eric Sims. Parties have conferred with Ms. Anderson in front of the court. Ms. Anderson is present for the fine recommendation that the referee recommended order be adopted. Which denies Mr. Sims parenting time. Is that correct, Ms. Zagorski?
Yes.
The court's aware of the background facts, circumstances. What about therapeutic or supervised parenting time with family counseling shelter services?
Yes, I know that's an option, Judge, but as I've set forth in my response in my brief, Mr. Sims has not shown that he is compliant with any of the prior orders of the court, that he's compliant with his probation, that he's getting mental health treatment. He hasn't provided any evidence that it would serve the child's best interest to be reintroduced to him. As I've set forth in my response, every year there's an issue, and this child is doing well. He's doing well in school. He's doing well with his extracurriculars. And before we risk his emotional well-being again, it seems that Mr. Sims would have to carry his burden of proof. Mr. Sims misrepresented himself when he was before you the last time and said that the minor child wasn't present during the last incident. The minor child was in fact present, and I've attached the text that verify that from Mr. Sims' own mother, in which state that this child should not have any contact with Mr. Sims. There's simply no reason to disturb this child's current situation until Mr. Sims can show that he doesn't pose any risk to the child's emotional or psychological well-being. Every single year we have this problem. Mr. Sims has assaulted his parents multiple times, at least 2 women in front of the child. My client has been a victim of his violence. Law enforcement has been a victim of his violence. And so it seems to me that we're doing what we've always done without Mr. Sims providing any verification to the court that it would be good for this child. And so I am asking that until he comply with this court's previous orders regarding showing documentation of compliance with his physician's treatment plans, compliance with probation, that he's taking his medications, that he give us some reason to reintroduce this child into his life, that his requested relief be denied.
Thank you, Ms. Gorski. Mr. Sims, Ms. Gorski does have a good point. First of all, you're currently still on probation. Are you in compliance with your probation?
Absolutely.
Okay, what the court's really gonna want is some documentation that you are actively engaging in active mental health treatment.
So we discussed that the last time I seen you, and you had asked if I was in any anger management program, and I told you that I was court ordered to take a moral recognition therapy class, and I completed that on the 17th of this month, and I was on house arrest for the first 6 months of me being out of jail, and I completed that without any issues. I've been compliant and taking all my psych meds since the first day of jail when I myself requested them. I have a blood draw this coming week to check my medicine levels, see if they need to be adjusted at all. I've done everything asked me by probation, including completing the MRT and taking all my medicine as prescribed by my physicians in and out of jail. And for the record, my son's never physically witnessed me ever commit any act of violence. The day that Miss Toll's lawyer just mentioned, Caleb was on a different floor of the house, and I don't even believe that he even heard the dispute, but there's no physical way, unless he can see through the floor, that he's seen anything occur that day.
Well, you were arrested, correct?
Not that day.
Okay. Okay, well, again, we need to, do you still live with this Alyssa Kennedy?
Absolutely not.
All right. Okay, well, Mr. Sims, I do recall you talking about a program, and I do not familiar with it, moral recognition therapy. I'm not sure what that is, but we need the court's documentation explaining what that is and that you are in compliance, and some documentation that you are in, you're taking the prescribed medications, and that this MRT or whatever it is, that's a form of mental health treatment. We need some documentation rather than just your verbal statements.
Yeah, so I showed that documentation to Emily with the friend of the court earlier, and I was unaware that I had to bring physical documentation into the front of the court or the courthouse in general. Otherwise, I would have been more prepared for this. I would have got a letter from my probation officer, who I believe thinks pretty highly of me. I've been doing pretty well for myself. With the exception of this winter, I haven't gotten a job since I got out. I'm running my own business. I mean, I would have completely came in here prepared with proof of what I've been doing. So I apologize for that, but there's no denying that I, in fact, have bipolar disorder. It's been a pretty terrible roller coaster ride thus far, and every time that I've ever been arrested was a direct result of me not being on medicine. I was unaware that I had bipolar disorder until diagnosed in 2018 when I was found not guilty by reason of insanity. And I'm just trying to put a better foot forward every day and make my mental health a priority, as I didn't in the past. I put work over everything else, and that's what wound me up in jail again, because I was off my meds for over a year, I think, before I went to jail this past time. And I didn't think it was as important as it actually is. So that's where we're at.
All right, Ms. Gorst, have you seen any of this documentation?
He held up a letter today that appeared to be from Community Mental Health, but I was unable to read its content. I have absolutely no knowledge that he's compliant with his prescribed medication or anything else.
Right.
And I appreciate Mr. Sims' statement that he didn't know he needed to provide this, but I would respectfully assert that this court has ordered it repeatedly, as set forth in my brief.
All right, here's what the court's going to do: is the court's going to adjourn this matter rather than adopting it. We'll adjourn this for 30 or 45 days. Mr. Sims, provide Mr. Gorski and the court directly copies of as much information as possible. A letter from your probation officer saying that you're doing, you're in compliance. I don't know how often you see a therapist. Do you see a therapist with this MRT program?
Yeah, usually once or twice a month, but since I graduated from the MRT program and that person that, I was meeting with is being transferred to a different position, I'm gonna seek out my own private therapist, because that program's done. So the order that I've been bound to fulfill is completed. I want to seek private therapy someplace else.
Okay, that would be wise, and you can talk to that therapist about your desire to maintain and redevelop a relationship with your son. But so I don't know what the date of this. I guess the final MRT report, which explains the program and all your compliance and successful completion. Do you have such a letter? Is that what you provided to Ms. Andrews?
I mean, the only letter that I got, I don't know if you'll even be able to read it. I can read it to you.
No, I'd rather you provide it. See if you get an updated letter, something that says you complete the program and describes the program. The court is not familiar with this MRT program. Does the letter describe what it's all about?
No, I mean, I'll read it to you. It's only 2 sentences. It just says, "My name is Joel McCrae, LMSW, case manager at Monroe Community Mental Health Authority and the Jail Diversion Department. I attest that Eric Sims completed MRT," and then his signature. So, I mean, it doesn't really describe what it is or what it entails.
Yeah, and I don't know how long you engage in that, how many sessions. The court needs more information about that.
That's been going on since I got out of jail.
Okay, so see if we can get some further information from Communal Health of what that program is about, and also how often you saw the therapist, or what did the successful completion of the program entail? Well, the court thinks we need that first and foremost, and obviously, yes, I think it's a great idea to engage in continued counseling. Who's monitoring your drug testing? Probation?
No, the doctor that prescribes my psych meds.
Okay, so maybe a letter from your doctor that you are testing the fact that you are taking all prescribed medications and that you are tested every other week or once a month or whatever.
Well, so the only way to prove that is usually with the medicine that I'm on, you do a blood draw once a year typically, and I had a blood draw like I want to say between 2 weeks to a month before I was released from jail. But I'm gonna go and have another blood draw done next week. So I mean that's the only way to prove that I'm physically taking the medicine.
Okay, so after you get that blood draw, a couple weeks after that blood draw, get a letter from your doctor attesting to those things.
Okay.
This is what you're prescribed, and he has verified you're taking those prescribed medications due to the following blood tests. So as much documentation as you can get would behoove you, Mr. Sims. So right now, are you involved in any counseling? Did you complete an anger management counseling program or just this MRT?
No, so like we discussed the last time, I didn't do any anger management. I did this because this is what I was ordered to do, and this is more thorough than anger management because it addresses your direct cognitive thought process. But as far as therapy, that pretty well ended when this was completed, which is why I'm seeking out my own personal therapy.
Okay. Court believes that's a good idea to get your own individual therapy and perhaps get a letter from that therapist. So find out what the agency, maybe your probation officer can recommend an agency, and you can make sure your insurance covers that service. But at this point in time, the court agrees with Mr. Gorski, we need some documentation that you, in fact, are in compliance with everything and that it's appropriate for you to reestablish a relationship with your son. Ms. Gorski, if you have any documentation or any evidence that suggests that the minor child saw or witnessed this assault, you say there was a text message?
Yes, Mr. Sims' mother, I attached it to my response. She indicated, we asked Caleb how he was doing several times after the fight. He kept telling us fine. That is the reason we didn't say anything. We believed him. We keep Caleb away from Eric always, et cetera, et cetera.
It's still not clear whether or not the child observed this incident. But I know there was prior assaultive incidents. Is there any evidence that the child was witness to prior assaultive incidences?
The child never
witnessed. The grandparents?
Yes, he was present when Mr. Sims put a cigarette out on his girlfriend's eye. The Department of Health and Human Services substantiated that in a report that was dated December 14, 2016. Has acted out inappropriately on more than one occasion, committing domestic violence against former long-term partner and currently against his own parents. And Michelle Sims with son, Caleb Sims present, and that was substantiated by CPS.
Right, goes back to 2016.
That was
sometime has passed. Mr. Sims seems to acknowledge that he has a bipolar issue and that he needs medication. So hopefully he is turning the corner to recognize that his past poor conduct was caused by that condition, and hopefully he's addressing that. perhaps at some point in time, maybe the front of the court can talk with Caleb to see what his, if he's got any concern about supervised parenting time, or the court was reluctant to have the front of the court involved. Maybe Ms. Toll sometime can get a sense whether or not Caleb would like to see his dad in a supervised, protected environment. So that's something you could talk there about. Ms. Gorski, but at this point in time, the court's going to adjourn this matter to the first week of March. So Mr. Sims can get together for the documentation. We have either March 5th or March 6th. Are you available, Ms. Zagorski?
Unfortunately, Your Honor, both those days I will be in Washington, DC at a conference.
Okay.
I
We'll
could
move it
do
up
the
then,
week
please.
before or the week after.
Maybe the week, last week of February.
Yep.
Mr. Sims, will that work with you?
Yeah, I can make it work. What time?
9:30. So, Mr. Sims, we want you to be productive. Can you get together all this documentation within the next, you got basically 30 days, and you get this to us in advance to Ms. Zagorski and the front of the court and to this court. You can get 3 copies of everything, one for the court. You can drop it off of the Braunlich window, the 4th floor, one for the front of the court, and then the one for Ms. Zagorski. As much documentation, the more the better. Certainly you want something from female health, explain what this MRT program is about, what that entailed. Ideally, something from your probation officer that you're in full compliance. And thirdly, a letter from perhaps your new counselor. You're gonna engage in continued counseling with your new counselor, and enter your doctor that you're taking all prescribed medications, and it's being verified. So we'll send out a notice to adjourn this matter to February 27th at 9:30. Anything further, Mr. Gorski?
No, thank you, Your Honor.
Right. Anything further, Mr. Sims?
No, that's I just want to clarify something real quick.
Okay, go ahead.
So I want to make sure I'm not underprepared the next time I come. So you'd like a letter from my doctor verifying meds in my system after the blood draw and compliance. A letter from my
Correct.
stating my progress in compliance with probation since release. A letter from my therapist describing what MRT is and what it entails, as well as my progress therapy-wise. Then I'm assuming you're going to want a letter from my new therapist and my progress.
Yes.
I meet with them any amount of time between now and then. I don't know what the new person's schedule is going to be like. And then who all did you say this needs to be delivered to?
To the court, Judge Braunlich, Ms. Zagorski, and the front of the court.
Okay.
So you just drop it off a day or two before.
Sounds good. I appreciate it.
Okay, we'll see you then. We'll send out notice February 27th, 9:30.
Thank you,
for-
Judge.
Okay, thank you. Now, who is ready to zoom out?
Your Honor, thank you. Your Honor, I've updated the recommendation. It should be in your queue.
Thank you, Ms. Andrus.
Thank you, Your Honor.
I'm taking.
Josh, you're going to handle that to mediation this afternoon, is that right?
Yeah, the mediation, yeah, I tried. The other party didn't show up, so the plaintiff didn't show
Okay,
up.
well, I've got to call into Musson because Musson should not appear. So French just said, I want a few minutes, I'm gonna get Musson to appear. And I said, well, if they don't appear, I'm gonna dismiss the matter. Musson
Right.
was the attorney of record when I scheduled this. Now he's claiming he's no longer attorney of record. I'm not gonna accept that.
Okay.
So you may need to be available in case Musson does show up with his client.
Okay, I can stay here and be available just in case.
Just to give you a heads up.
Hi, Jim. What case are you on?
I am on Hagedorn Statkowiak.
Oh, okay. I don't have you on there, so I'll put you in there. Hold on a minute.
Good afternoon.
Court is now in session. Jamie Brock versus Philip Brock.
For the record, this matter is before the court for continued pretrial conference subsequent to a scheduled mediation. Mr. Musson did not originally appear, but however, Mr. French indicated he reached out to Mr. Musson. Mr. Musson, where is your client, Ms. Brock?
She should have been here, Your Honor. I appeared on a limited scope appearance.
Mr. Musson, stop right there, Mr. Musson.
Okay.
Stop right there. Mr. Musson,
Yes.
you appeared at a pretrial conference on behalf of Ms. Brock on December 8th, 2023. A teleconference. You never told the court at that time you would not be appearing for the mediation. And your limited appearance says that when it ends, you will file a notice of read your notice of limited appearance. It says that when the limited scope representation ends, the attorney will file a notice of withdrawal. You've not done that. You're still the attorney of record, Mr. Musson.
I believe that was filed on the 18th or the 19th.
Show me that.
I can screen share it.
You have something?
I looked already. Let me look again.
But Mr. Musson, the court's I'm not gonna accept these from you anymore. Because when you appear at a pretrial and you say, Judge, I'm done, I'm not going to mediation, you need to tell me that, Mr. Musson. You've misled the court. I'm very disappointed.
Your Honor, it was
I will
not
not accept it. I will not accept from you, Mr. Musson, a future limited appearance. I will not accept it. So don't bother filing them in this court. With that, since Ms. Brock is not here, the court will dismiss the plaintiff's complaint for divorce.
Your Honor, if I may weigh in.
Mr. French?
Your Honor, would you give us a little time to amend?
No.
And file a.
You can take it up with Mr. Musson. Mr. Musson should have been prepared with his client here. The court is not pleased. So Mr. Brock can file his complaint for divorce. Mr. Musson, do not file limited appearances with this court again. You can file them in Wayne County. Don't file them with this court. You can zoom out. Not happy.
All right. Thank you, Your Honor.
Welcome.
We will refile, Your Honor, or file.
I'm sorry, Mr. French. You can take it up with Mr. Musson. I mean, he should have communicated with you that he was no longer involved.
He did, Your Honor. We'll just refile, or we'll file our complaint and keep the case moving.
He's telling everyone but the court that he's out of the case. And Mr. Musson, do you understand the court's point? You should have told the court back in December when we conducted this pretrial, when I sent this matter during the coordinate with your schedule that, oh, Judge, I'm not going to be there. I'm done. I'm going to file my dismissal, my withdrawal. You never did that.
I could certainly explain that if the court would like me to explain that.
Why did you tell me when we did the pretrial conference on December 8th that you were not going to be here for the mediation?
Because of the way the limited scope works, I put in for an addendum to be added to cover the mediation, but my client didn't approve it. And she said, no, I'm not going to have you cover the mediation.
All right. Well, this court's not going to accept the limited appearances, Mr. Musson. So don't file them with this court. If you have a complaint, take it up with the Supreme Court.
Understood.
Matter is dismissed.
Thank you, Judge.
Welcome. Sorry, Mr. French.
Okay.
Okay. Josh Walker know that mediation's off.
I will, Your Honor.
Okay. I apologize. I mean, I don't know if you heard that. Musson appears in the pretrial scheduled mediation. Oh, I'm not longer representing him anymore.
Yeah. And the court had it right. It's those limited appearances. They give us a hard time too. So.
And of course, his limited appearance says when this limited representation ends, the attorney will file a notice of withdrawal. He's not done that. Just wasted everyone's time. Very, very frustrating.
Yep. And I believe the court's right. They allow those limited periods in Wayne County all the time, but we don't usually do it. So
this court's not going to accept them from that attorney.
yeah. Let me bring the other one out, Your Honor.
Okay, so you're bringing bottom 3.
That's correct.
Okay.
If you see a limited appearance with Musson, tell me. I'm gonna start right back to him. Once I'm back to him, say it's just not accepted. I don't even want him to be filed. If you happen to see one, you may not see it until it gets in the file. But I
don't see anything filed as of now.
Well, I'm talking about any other future files. And not from him, I will not accept them.
Okay.
You said it was like the 19th. You think you didn't get it yet, or?
No, because no. I go through everything.
I mean, I'm thinking you said you didn't send it till the 19th. I wonder if you didn't get it.
And then I go through that stack twice a day.
What do you think you do, a judge?
Yeah.
Copy. Just to be safe. Okay.
For the record, this matter is before the court on the plaintiff father's motion to modify parenting time and other relief. This hearing is being conducted via Zoom. Present is Attorney Alexis Spencer representing the plaintiff moving party, Jacob Hugendorn. Mr. Hugendorn is going to be present with Ms. Spencer. In addition, Attorney James Andre is present representing the defendant mother, Chelsea Sedkowiak. Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon, Your Honor.
The parties have met this afternoon with Ms. Patrick, who is part of the court's fine recommendation. Someone know the parties agreed to attend mediation regarding the motion to modify parenting time. Did you schedule a date, time?
No, Your Honor.
Your Honor, Ms. Spencer is going to coordinate that through the front of the court and then with Mr. Adre's office. Unfortunately, Mr. Adre has suffered a recent loss, and we thought that was the best way to handle that.
Okay. All right. So we will not put it back in the court's docket at this time. It can be renoticed up unless the parties can reach an agreement. Is that correct?
That's
Yes.
correct.
Okay. All right. Anything further, Ms. Spencer or Mr. Adre?
No, thank you, Your Honor.
Nothing, Your Honor. Thank you. Thank you,
All right.
Patrice.
All right. That concludes the matter. Thank you. You can all zoom out.
Thank you, Your Honor.
Conducted via Zoom. President Attorney Alex Goldman representing the plaintiff, Jordy Sonnenschein Schmitz. Ms. Sonnenschein Schmitz is present. In addition, defendant father Joshua Gibson is present. Good afternoon, everyone.
Good afternoon. Your Honor.
Parties have conferred with the front of the court. Mr. Walker, I believe, and court has received the fine recommendation. On a temporary basis, without prejudice, parties shall share joint legal custody of the two minor children of the parties. Physical custody is reserved. It's further recommended that parenting time shall be exercised as follows. And of course, during the custody, Mr. Gibson and Ms. Schmitz means that two of you share equally any major decisions concerning the welfare of your children, like medical, health care, education, religion, things of the important decisions concerning the children's welfare. You both need to communicate and share that information with each other and agree upon it. If you cannot agree, then you need to petition the court and have the court decide. With respect to parenting time, mother shall have parenting time as follows. Week 1, mother shall have parenting time on Saturdays from 4:30 p.m. to 7:30 p.m. Thereafter, presumably that started this Saturday. Thereafter, parenting time should be Saturday and Sunday, 4:30 p.m. to 7:30 p.m. Only family members shall be present during mother's parenting time. All exchanges shall occur at the St. Mary's Park here in the city of Monroe. Parties shall use app close for all communication. Mother shall video chat with the children on app close every weekday at 5:30 p.m. for a minimum of 10 minutes. And the party shall appear back before this court to review parenting time and any other issue on March 5, 2024 at 10:30 a.m. That is the recommendation. Mr. Goldman, is this recommendation agreed with your client this afternoon?
It is, Your Honor, and I would just add that we clarify that phone call starts this afternoon.
Okay, 5:30 this afternoon, and mom's parenting time will begin on Saturday, 4:30. The children right now are with dad?
Yes, sir.
All right.
And Your Honor, I have one more request.
Yes, Mr. Goldman?
That all future hearings be held in person. I'm concerned about off-camera participants.
I agree, because I just got a text from his wife stating that he knows things about the custody that he shouldn't know if he's not there right now.
You say his wife. Who are you referring to? Who's he?
Her, Mrs. Sonicson's boyfriend's wife, messaged me stating that he knows things about the case, and how would he know things if he's not there?
I can show my room. I don't have anybody in my room.
Okay. Mr. Goldman, it's sort of cumbersome. Generally, the court will permit in person. First time this court's had an in-person request other than for an evidentiary hearing. Again, obviously, Mr. Gibson, if random people are texting you, ignore it. Don't block their texts. People are just stirring you up, Mr. Gibson. I have no idea who's getting information about what. The court file is a public file. Anyone come in?
No, I understand that. I understand that.
So
Sorry,
I'm not sure if you're talking, Mr. Gibson. Mr. Goldman, you're concerned about other people being present in the background. Mr. Gibson, are you by yourself right now?
Yes, sir. I promise. Wholeheartedly swear.
Your Honor, we heard people in Mr. Gibson's room during the front of the court hearing.
There was my nephew and my niece, and they were running around, but they're gone. I shipped them on out of the room.
Okay, Mr. Gibson, when you appear in court, you're in court. So you should go out to your motor vehicle. You should be in a room with the door closed.
I went upstairs to my area. I'm sorry, Your Honor.
Okay. Well, from the now on, you put yourself in a in a quiet
quiet
area
room.
so you can properly appear in court
Yes,
without
sir.
disruptions.
Yes,
Right,
sir.
Mr. Goldman, if in fact it becomes a problem again in the future, we can address that.
Certainly, Your Honor.
But the court does not have this problem before, so if in fact there was a problem on March 5, which would be via Zoom, we can address that again at that time. So don't hesitate to raise it at that time if it continues to be a concern.
Very good, Your Honor. Thank you.
All right, otherwise the recommendation is good with your client then?
It is.
Okay, and mom has dad's phone number, correct? Or I'm sorry, it's gonna be an app close. So you're gonna video chat through app close, and they both can load that up with that app on their phone. So Mr. Gibbs, you understand this will start at 5:30 tonight. Make sure the kids are there. They let them know they're gonna talk to their mom, put them in a situation, and have them focus in, and so they can talk with mom. Now, mom, this is a 5 and 2-year-old. I've got
The
grandchildren
2-year-old's
that age
not going to really
sometimes.
pay that much attention.
Hold on,
He
Mr.
likes
Gibbs,
to
don't
run and
interrupt.
play.
Mr. Gibson,
Sorry.
don't interrupt.
Yes, sir. I'm sorry.
This mom, you need to recognize sometimes their attention span is not that great for that young of an age to be able to sit and talk with you for 10 minutes. It's not like a 10-year-old. So be conscious of that. It may you want to just see how they're doing, have a tell them that you love them and so forth, but it may not last for 10 minutes. But you got to both play by ear. And Mr. Gibson, you should don't interfere with those conversations. Let mom have that. The children's attention be directed to mom.
Okay,
Understood?
Your Honor. And if I may I ask a question?
Just know in a few minutes. Mr.
Yes,
Foreman,
sir.
is there anything else you wish to add?
No, Your Honor. Thank you.
All right, Mr. Gibson, it's your turn.
And if our oldest refuses to do so, what do I need? What should I do, Your Honor?
You set him on the couch with his other sibling and tell him that they're going to talk with their mom.
Okay. All right.
If he gets restless, he's got to tell his mom that. But no, you tell him that this is time to spend with their mom, and you can sit him on the couch there.
Yes, sir. Thank you.
To mom. All right, so okay, then you're meeting at St. Mary's Park at 4:30 on Saturday, and then again at 7:30 to make the exchanges. Any questions, Mr. Gibson?
As of right this second, no, I think we've.
All right.
I'm still allowed to obtain an attorney?
Sure. At any point in time, you can contact an attorney.
Okay. I'm just making sure about that.
Keep in mind that children need an active dad and active mom in their life, so you need to encourage that relationship, Mr. Gibson.
I agree.
You care about your children.
Yes, I do.
Encourage that their mother loves them. You need to tell them that, and that they need to have a relationship with their mother. So that's important from both sides.
I agree.
Goldman, Jewish of your client at all regarding this recommendation this afternoon?
No, Your Honor.
Okay. All right. Court will adopt the recommendation. Will become an order of the court. Copy mailed out to Mr. Gibson and to Mr. Goldman. All right. That'll conclude this matter. You can all zoom out.
Thank you, Your Honor.
You're welcome.
Thank you.
Thank you.
You're welcome.
How you doing today, Judge?
Wonderful. How are you?
I'm good as can be, sir. Thank you.
We're just waiting for Robin to connect.
She's here, but she doesn't have anything connected.
Well, she still has this, or no, she doesn't have the same phone. As I say, her smartphone ain't too smart, so she might be having a problem with it.
No, she's here, but we don't have any connection.
For the record, this matter is before the court on the motion of the petitioner Robin Knight to terminate first protector entered on November 29th, 2023. This hearing is being conducted via Zoom. Is Robin Knight present on audio?
I'm here.
Are you Robin Knight?
Yes, I am.
All right, so Ms. Knight is present, and District John Knight is appearing via Zoom from the Monroe County Jail.
Yes.
Ms. Knight, in your motion, you indicate that Mr. Knight's not getting out of jail anytime soon. I don't remember signing the papers for the PPO. I was so in shock. I'm not afraid of him anymore. Please drop his PPO.
Your Honor, I don't mean to interrupt you, but
hold on. Let's hear.
Okay.
Let's hear from Ms. Knight. Ms. Knight, that's correct.
Yes, it is.
Do you know what you're doing today?
Yes, I do.
Okay. All right, Mr. Knight, do you want to say something?
Yes, sir. I'm on $1 million bond. Even if the 10% did come up, there's no way in the world I'd be able to bond out. So there's no issue of me being able to get out. I'm here for the duration.
What are you charged
So there's attempt murder, a felonious assault, attempt murder.
Yeah, Rob Knight was a victim of that. Is that
yes.
correct?
Yes, yes, sir. Yes.
Okay, have you had the preliminary exam yet?
We did, I don't know the correct terminology of all this, but we did the first court session. The second one is been postponed until the 6th, which is coming up here in a few days, for a forensic review. There's been a motion to give to the prosecutors for a plea agreement, which I've briefly talked with my attorney on this, and Robin, from what I understand, Robin has gone in and talked with the prosecutor. The prosecutor wanted 10 to life, and from what I'm understanding with my lawyer, that's been taken off the table, and they're rethinking a plea agreement on this. Beyond that, I don't know. I can speculate of what's going on, but I don't know the exact situation that's going.
All right. Ms. Knight, these are serious allegations. The court can't control what happens if you decide not to pursue prosecution. Mr. Knight was apparently charged with assault, attempt to murder. These are allegations that repeatedly in the face made the threats that I'm going to spend the rest of my life in prison for this. The serious allegations. This court does not grant PPOs one day and terminate them the next day. So this court will not terminate this PPO. So even if the criminal charge is dismissed, Mr. Knight is released. Mr. Knight, you cannot have any contact with Robin Knight.
Yes, sir.
Have it through an attorney.
I'm sorry?
Two of you are married right now, or divorced?
No, we're still married. So we've been married 25 years.
So any contact you have with Mr. Knight, do that through an attorney, Mr. Knight, okay? This
Yes,
court
sir.
will deny the motion to terminate the PPO. These allegations are too serious. Court wants to make sure Ms. Knight is adequately protected. Ms. Knight, we have the same address for both, 20?
No, I'm not there anymore.
Okay. Did you have you provided post office with a forwarding address?
Yes, I have.
Okay, so if we mail this to you at that address, it will be forwarded to your new address, correct?